Hello, folks. I am Lloyd Copenbarger, and I'm going to be your host today with this webinar, Protecting Your Real Estate. I see that we have quite a number of people signed up for this, and hopefully I can answer most of your questions in the permission that we're going to be making under these discussions. And to the extent we fail to answer any questions you have, don't hesitate to contact our office. Myself or one of the other attorneys will be honored to help you get answers to your questions. First of all, though, let me go over today's agenda, and that will help you focus on where we're going to be discussing. First of all, we're going to discuss the effects of Prop 19 on those of us who live in California and have California real estate. That is a provision of the law that was changed several years ago. It has had a profound effect on real estate ownership in California, and more specifically on the transfer of that property from ourselves to our loved ones in the event of our death. So that's going to be something that I think most of you will find very much of interest. We also are going to be talking about how you can protect your property. There are a number of factors that have to be considered when you're a property owner. We're going to discuss some of them. But we're also going to spend some time talking about how you transfer property. What's the best way to shift ownership from yourself to someone else other than when you're just selling it to a new buyer? And I'm primarily concerned about transfer to family members and to loved ones in the event of your death. So those are the things that we're going to be discussing. And then finally, we're going to talk about how we can be of help to you as a law firm meeting your needs. One of the things that I want to point out to you is this is not a one-man band. Although I'm the attorney who founded this firm, we have a substantial staff of people who are highly qualified attorneys. Several of the attorneys are state board certified specialists in trust, probate, and estate planning law. Several of the attorneys have master's degrees in tax and law, and all of the attorneys have the ethic of trying to serve our clients to the best of our ability and to do what's in the client's best interest. So whether you're dealing with me or a member of our staff, the benefits from dealing with us is I think you'll be dealing with people who are truly concerned about meeting your needs and making sure that you're properly advised and assisted. For your convenience, we have offices in several locations throughout the state of California. On the slide before you, you have those locations. I'm not going to go down the list, but you can see that we have offices in many of the population centers in California. And with the benefit of using Zoom, we have an office anywhere someone wants to reach us by Zoom and have a meeting with us. And the benefits of that meeting I'm finding is that it's as though you were in our office regardless of where your physical location is. Recently, I had a meeting with a client who lives in Mumbai, India, his financial planner who was in New York City, and I was here in our main office in Orange County, California. So with that capability, we're accessible to almost anyone who would desire to receive our services. I also introduced you to our staff. They are a substantial group of dedicated people whose only purpose is to take care of the needs of our clients and make sure that we present the service to you that we profess that we're going to. And so we have been blessed with a very fine group of people who fulfill that role. We're going to be talking today about real estate, but we're also going to be talking about taxes, laws, and legacy. And you can see on the screen what I believe is very good advice to young families. As a matter of fact, one of our attorneys just left yesterday on parental leave, in welcoming his first child into his family, and we're blessed to have a number of young people who are serving in the law at the same time they're taking care of their families. My first area of discussion today is going to be Prop 19 and give you an overview of it. Prop 19, as I've already indicated, was brought into the law of California by a constitutional amendment. And primarily it was facilitated by the real estate industry because they wanted people to have to sell their properties in the event of their death and get those properties back into the real estate market. And it has some good points, but it also has some very serious bad points. The primary good point is that it allows you, if you want to sell your existing home and move to another residence in the state of California, to allow you to take your tax basis to a replacement residence, so that you don't end up facing a huge increase in your property taxes if you need to move to be closer to children or to other family members, or if you're just wanting to downsize and remove yourself from the burdens of managing property that was quite appropriate when you had a young family or when you had many members living with you, but are no longer suitable for your present circumstances. The bad part of the law is it seriously affects the transfer of property when someone passes away to children and grandchildren. And so that is something I want to spend a few minutes talking about, because those bad effects are something you need to be aware of. Sometimes you'll be able to take steps to avoid that problem, and I'm going to talk about how that can be done. Before I go to that area, though, in addition to people just moving to another location who are over the age of 55, there are also provisions in the law to allow people who are severely disabled, who are victims of fires or natural disasters, to move without having their tax base increase. We had a number of clients who were affected by the Paradise Fire, and so this provision has been beneficial for them. In order to qualify for it, they have to have been original homeowners and have homeowners exemption, or they have to do it within 2 years of the purchase of the new home. And I would recommend, if you're taking advantage of this provisional law, that you file that homeowner's exemption at the same time you acquire ownership, and make sure that you don't find yourself forgetting to do it and lose that benefit that the law provides. This law went into effect April 1st, 2021, so it went into effect right at the very beginning of the COVID period, and because of that, it didn't get the attention that it probably should have received. Let's talk about the only protection that's in it to allow you to protect the parent-child exclusion and retain your property tax for a child. And that's where you give the property to the child by sale or by provision in your will, and the child has to live in the home as their primary residence. And so that creates a dilemma, particularly if you're trying to treat your children equally, and you're an ordinary person here in California, where your home may now be over $1 million in value when you purchased it and it was less than $100,000. There are ways to deal with this, and we're going to talk about it in just a few moments. This should be dealt with your attorney, and those of you who are clients of Copenbarger Copenbarger, if you've attended one of our client seminars, we've already talked about the importance of putting a right of first refusal in your trust, permitting a child or children to have a right of first refusal to purchase the property from your estate in the event of your death. That allows the child to qualify for that parent-child exemption, and it allows them to avoid the property tax step-up, although it's not quite as good as it sounds, because it only covers a certain amount of the property value. And so if the property has a value of more than if the property has a value of more than $1,022,600, then you get assessed increase in taxes for the value over that. And so that does have some mitigating benefit to the use of the parent-child transfer for the primary residence. For all other property, it's almost impossible to escape the step up for property tax purposes in the event of a transfer to a child. And so I would recommend that if you haven't already acquired property that you intend to use as an income property, say a rental property for a rental home or apartment or condo, or a property to rent to a business, that you consider creating an LLC, a limited liability company, before you acquire that property, and you put the property in the name of the LLC at the time of purchase. This has several benefits that are quite significant. First of all, it protects you from liability that might be generated by the property. For example, someone gets injured on the property and you're not involved in it, just they slip and fall or something like that. The only risk that you have is the loss of the property that's in the LLC. They can't go after your home. They can't go after your bank accounts. They can't go after your retirement benefits. And it also protects all of your financial resources other than what's in that particular LLC. It also has the primary value that you can transfer that LLC to the people you want to own that property after your death. And since the title will not change because it's in the LLC, the assessed value for property tax purposes will be kept at the original purchase price, which allows you to not have a step up in property tax basis upon the transfer to the family member or the person you want to become the owner. So that's something you may want to talk to us about before you buy a new property as part of your investment portfolio. Let's talk about protecting property. Real estate is one of those areas that the way the title is held really has significance. And I'm sure all of you have seen the television ad where the guy who's an ex-con is talking about how he can take your property and all he has to do is get a quitclaim deed and fill it out and sign it, and your property is his. Well, I got good news for you in California. That just won't happen. We dealt with that about 20 years ago, and all transfers of property or documents that can transfer property, like powers of attorney or trust, the person who signs the document must put their thumbprint in the notary's book at the time the document is notarized. And so if the question of title comes up, all you have to do is demand to see the notarization booklet and compare the thumbprint of the person who signed that using your name and verify that that is not your thumbprint. And that is prima facie proof that you didn't sign the document. I had an interesting case a number of years ago where a lady came in and she was elderly and she thought her son had stolen her property by getting a deed and putting it in his name. And so we got the notary book, and lo and behold, it was her thumbprint. And she had just forgotten that she had transferred it to him many years before. But it avoided a serious conflict within the family because she had told some of the child's brothers and sisters that he had effectively improperly taken the property from her, and that clarified that, so kept peace between the siblings. Joint tenancy with right of survivorship is a commonly used method of ownership to transfer property to someone you want to receive it when you die. It has a number of problems with it that you should be aware of. First of all, it can avoid your ability to have a step up in basis on the property unless the joint tenancy is properly held. And that requires some legal advice to do it. And even then, it's difficult to accomplish. It also can result in property going through probate if the order of death is not what you imagine it would be. Let me give you an example. Let's say my wife and I own a property in joint tenancy with right of survivorship, and we're out on the freeway driving, and we're involved in a serious accident, and I'm killed at the scene. And Laura lives 120 plus hours after my death. The property goes from me to her at my death. But when she dies 121 hours later, or if we both die together, that property is going to have to go through probate to get to the people that are entitled to receive it, either under the law of survivorship, heirship, or through whatever legal documents we have in the way of a will or other document that would transfer that property at our death, whether it was transferred under the will itself or whether it was transferred by the will into a living trust. Either way, the value of that property in California is going to be greater than the amount you can transfer without having to go through a formal probate in California. So I encourage people not to use joint tenancy with right of survivorship without talking to a knowledgeable attorney about the pros and cons before you, in fact, utilize it. Other forms of ownership where you have ownership as tenants in common or a fractured ownership where several different people have percentage ownerships in property. That has both benefits and problems with it. In large estates, we use that to our advantage because the law recognizes that the whole is worth more than the sum of its parts. And so if you own all of something, you can sell all of what you have and get whatever the value is. If you own half of something, you're not going to be able to sell it to a third party and get equal to half the value of that property because they're going to have to deal with that other owner, and that reduces its value. And the tax laws have recognized for years that that may be as much as 20 or 30% of the value of the property. Not to mention the problems of having to go through some kind of division of the property through the court system in order to get it sold or to get your interest in the property out if the other owner is not cooperative with you. Community property ownership is a good form of ownership of property. I prefer to see it done in a living trust as opposed to a joint tenancy with community property rights, primarily because Again, the order of death doesn't matter when it's in a trust. The trust survives whoever is the owner of the property, and the trustee does with the property what the trust document instructs them to do. And so that's a good form of property ownership. Certain partnerships are a good form of owning property. Again, though, I go back to what is going to be my last suggestion, is it's best to own property in trust as a trustee, because you always can name who you would want to take over if you couldn't manage the property yourself as the trustee, and you can give them instructions as to how you want the property utilized in the event of your death, or utilized for you in the event you're living but unable to manage the property yourself. The key question you always need to ask yourself is there any scenario under which the property that I own would have to go through probate in the event of my death? And that is the key question. If you don't know the answer to that, again, I would encourage you to talk to someone at Copenbarger Copenbarger and let us help you determine what that answer is, and then you can determine whether it'd be to your advantage to make a change in that form of ownership. Remember that when you put property in a living trust, it is controlled by the trustee. Usually you are that trustee as long as you're living and as long as you're competent. In the event of your death, or the death of the last surviving trustee of the trust, if it's created by a husband and wife or by two parties acting together, is the administration of the trust. And the trustee is the legal owner for the purpose of transferring that property, even though the trustee may not have any equitable ownership in the property at all. And it allows that property to be transferred out of the trust to the beneficiary, and it avoids probate in the process of doing it. Another advantage of the living trust is that it allows you to put provisions in the trust that can be quite beneficial to the people who are your beneficiaries. For example, one of the things you can do in a living trust is put a provision that we call generation skipping trust, but more properly in our trust, we call it a protective trust, because it does several things for your children. It doesn't do anything for you, but it does several things for your children. First of all, what goes to them free of tax to the extent you are not subject to federal or state tax on what they receive yourself. Right now, that provision allows you to transfer about $13 million free of tax in the event of your death. A husband and wife, together with a properly prepared trust, can transfer up to 26 million, almost 27 million, and avoid any federal or state tax. Now, that's going to change shortly. First of all, it's scheduled to sunset in 2025 and will drop down to somewhere between $5,000 and $7,000 per person, which is about half what it is now. And depending on the political outcome of the presidential election, one of the parties has promised they're going to increase the federal estate taxes if they are able to come to power. So that's another factor that has to be considered in tax planning and in the tax planning that you can do for your children while you're still alive, that will benefit them and your grandchildren when you're gone. But anyway, what's key to remember is that this particular provision you can put in your trust for your children keeps anyone else from taking their inheritance from them. In other words, you leave an inheritance to a child, a divorcing spouse of that child cannot get any of your child's inheritance if your child leaves it in that protective provision you've made for them. If they're in an automobile accident, and gets sued and a judgment's rendered against them, a court can't levy execution on the money that's in that generation skipping protective provision. And finally, if the child gets into financial trouble themselves and have to file bankruptcy, the bankruptcy court cannot access those funds to repay creditors. And so that's a pretty significant benefit that can be put in a living trust. Also, in a living trust, you put that provision I've already talked about, a right of first refusal to allow a child to purchase your primary residence. And another benefit, particularly if you are in a second marriage, you can give a life estate and property to your spouse and ultimately have the property go to your children or other people at your death. So those are some of the advantages that are available. Now, there are other ways to protect property, and I'm going to go over these pretty quickly. If you have specific questions about them, again, I would encourage you to contact our office. First of all, certain irrevocable trusts can be very beneficial. For example, one of the things we have done in our practice for a number of years is create irrevocable trusts that allow people to qualify for Medi-Cal benefits here in California. The Medi-Cal laws have changed, but there are trusts that still allow you to qualify to receive Medi-Cal benefits when you otherwise would not have been able to. There are charitable trusts that you can create if you are a person with charitable motivation that can provide really significant benefits to you while you're alive. I like to say that they can increase your usable and spendable income while you're living, and at the same time provide significant benefits to a charity at your death. And basically what they do is they allow you to transfer appreciated capital gain property to this charitable trust. The trust doesn't recognize capital gain, and you don't either. The trust is a charitable interest for legal purposes, so you get a charitable tax deduction based on the amount that ultimately will go to the charity at your death or at the end of the charitable trust term. That allows you to receive a current income tax deduction equal to the value of that charitable deduction. And if you're a mature person, and by that I mean someone over in your 70s or 80s, that charitable deduction is a substantial percentage of the actual property value. And so that can be used when you're selling property or selling a business to protect the part of the property that you want to receive cash for yourself by creating a deduction in the charitable trust that will shelter the portion you want to receive so you don't have to pay taxes on that. Anyway, it's complicated, but we have experts in our office who can provide you the answers to your specific circumstance if a charitable trust would be beneficial to you. LLCs allow you to protect yourself from your property. LLCs do not protect the property from you, but they do protect you from the property. And by that, I mean, let's say you have a rental house, and just be wild, let's say it's down at Balboa Island, and you rent it out to people for the summer or for vacation periods, and somebody gets hurt on those premises, and they sue you. If that is in a LLC, they can't go against you personally. They have to go against the LLC. And if they are successful in their lawsuit, all they can do is get the property that's in the LLC. They cannot take any of your other assets. And so if you have properties that are high risk properties, where they're rental properties or where there's likelihood of a lawsuit arising out of that property, an LLC is a wise consideration to consider. There are other options that can be utilized. The one option I would never recommend is using corporations to own real estate. That can end up with you paying taxes twice on the same gain. You also need to have special planning sometimes for oil, gas, and other minerals. Those are very valuable assets if they're producers. And so it's really important that that the titling of those be held properly so that there's no issue about them when the time comes that they need to be transferred after your death. And also, I would encourage you, before you buy property or before you sell property, that you pick up the phone and call the law office and discuss with us what you're intending to do, and make sure that there aren't any problems associated with it you haven't considered. For those of you who happen to be members of the Access Program for Copenbarger and Copenbarger, you know it doesn't cost you anything to pick up the phone and call and speak to an attorney and get advice over the phone. So that's something that obviously those of you who are members of Access need to be aware of, and you need to take advantage of. Probably the most important thing in protecting property is to make sure the deeds and other documents involving the property are properly titled. If you don't have the right legal description, or if the properties aren't properly signed by the right people, that can end up with a problem that can arise 5, 10, 15, 20 years later. And so it's really important that those deeds and other transfer documents be properly prepared and properly filed. It's such a serious issue in our practice that we won't let people that we create a living trust for do their own deeds if we can prevent it, because we found that people don't record their deeds, or if they do record them, sometimes the deeds are created with errors in them. And when we do it, we try to always do it right. And if we don't do it right, our malpractice coverage protects anyone who's harmed. And I can sit here and tell you, after 55 years of practice, I've never had a malpractice claim that was realized. So at this point, at least, knock on wood, we've done a good job. Excuse me. Another issue in moving to another state is question about your documents. Well, let me speak to that in general terms and then speak to it in more specific terms. When you create a living trust or other legal document, that document is valid in any of the states, because under the Constitution, things that are done in one state are required to be recognized by another state. The only issue you need to consider is, does the state you're moving to have different tax laws or other circumstances that could be to your advantage if the document you have were updated to take advantage of those provisions? In very few cases does that actually happen, but it is sometimes a concern. Again, if you're moving to another state, it may be something you'd want to talk to us about. Sometimes we're able to help you in the new state, sometimes we're not. But we will always tell you what we believe is in your best interest, so that you can take care of those issues in whatever your life circumstances have to be. If you need to make changes, and if those changes don't require a local attorney to make those changes, in most cases, we can make those changes for you out of our office here in California. The only state that that's an exception in is the state of Florida, which has very rigorous attempts to prevent attorneys who are not licensed in Florida from doing any legal work within the state of Florida. And so in most cases, if serious changes need to be made that involve Florida law, we will send you to a local attorney in Florida, or we will ally ourselves with a Florida attorney so that you're properly protected. The key thing in all trust situations is be sure that when you acquire something that has a title, that you take that title in your name as trustee of the trust so that it is properly protected in the event of your disability or death. Now let's shift and talk about transfers of property. When you sell a property, if it's to a third party who is not related to you, or you're not trying to provide any benefit to, then all you need to consider is whether or not it's something you need to try to utilize some type of 1031 exchange or other method to avoid recognition of the income at the time of the sale. There are a number of ways to utilize the 1031 exchange. Obviously, the most obvious one is to acquire similar property and purchase that, and in effect exchange one ownership of property for another. There are also provisions under the law of Delaware for a Delaware statutory trust that can allow you to transfer funds to that trust that qualify for a 1031 exchange. It's more complicated than I want to talk about here, but if you don't have exchange property, or you don't want to get in the business of managing property, that Delaware statutory trust may be something you'll want to consider. Anytime you want to make a gift of property to someone, you absolutely must remember that when you gift the property to them, you gift your cost basis. And that is a very serious issue here in California, where property values have increased so much over the last few years. Let me give you an example. The first home I bought in California was back in 1963, and I paid $8,000 for a house that today, I wish I owned it, but it's probably worth a little over $1 million. If I had purchased that house back in 1963 and had owned it to now, and I wanted to give that to my children as a gift, they would be exposed to almost $1 million in taxable transfers. That could end up with them paying an income tax if they sold that property on almost $1 million. That could be as much as $300,000 in actual income taxes paid. Now, there wouldn't be any gift tax made by me if I made it now, because I can gift up to $13 million under present law without having to pay tax. I just have to file a gift tax return. But I would be giving my children a tax bill of almost a third of the value of the property by giving it to them during lifetime. If it's possible, it is much more beneficial for you to give it to them by inheritance, because under present law, if they inherit it from you, they get a new cost basis equal to the value of that property at the date of your death. And so using that same example that I just used of the difference between a house that cost $8,000 then and is worth over $1 million today, they would get a cost basis today of $1 million, and they could sell it for $1 million and pay no capital gains tax at all. So as you can see from those examples, this is a significant consideration particularly if you're a mature person and you see inheritance being an issue that will arise sometime in the near future. Now, one of the problems that frequently arises is when you're trying to provide all of your children in an equal way, when you have assets that don't easily equally divide. And there are several ways to approach that. First of all, it's important to remind yourself that the only fair is in Pomona. You don't have to be fair with your children. You can treat them as you did when they were young and treat them on the basis of their circumstances and their needs. But let's say that you do want to, in fact, treat them equally. And in your mind, that's really important to make sure everybody ends up being viewed as being treated equally by you. Then that can be done by either liquidating the property and distributing cash, or it can be utilizing what I call gifts in kind, where you give property, a specific property to a child, but to the extent that property either exceeds or is less than the interest that they would be entitled to as a share of your estate, they either have to put money in the pot for the other children, or if the other children get more, they have to put money in the pot for that child. And in that way, in the administration of your estate, everybody ends up equally in an equal financial position. And I would encourage you to consider that. Same thing is true with any type of property ownership, whether we're talking about real estate, whether we're talking about oil or gas or mineral interests, whether we're talking about rental or investment properties. The only property that has any issues that you have to try to factor is when you're giving your primary residence to a child who's going to occupy it as their primary residence, because you are giving them a substantial benefit from a property tax standpoint, because they're going to be able to keep your property tax basis, and that may be thousands of dollars in property taxes cheaper than it would be if they had to realize its current fair market value. So that's just an issue for you to consider when you're dealing with deciding how to divide property or divide property to your children. I have found that if I talk with clients about their individual circumstances, talk about what the circumstances of their children are, we usually can work out a solution that treats everybody appropriately, and most of the time that's equally, and at the same time doesn't create hardship or any misunderstandings on the part of the loved ones when you're gone. Property tax issues in California, the only advice I can give you is try to keep your property tax as low as you can. I really like the concept of using an LLC for any property other than a residential property. If you do have a residential property and you have a child who wants it or can use it as a primary residence, that can be worth thousands of dollars in tax reduction over a period of that child's occupancy of the house as their primary residence. Anything you can do to avoid property tax reassessments is wise. Anything you can do to minimize recognition of capital gain taxes and actually having to pay them is wise. Anything you can do to plan your estate in such a way that you avoid federal estate taxes is wise. And that's an area that even if your estate is greater than the amount that the law says you can pass tax-free, one of the expertise we have here in the firm is helping people utilize provisions in the federal estate tax laws that allow you to transfer property at death without paying taxes, even though you otherwise would have to. Every tax law I've ever seen has a back door in it that you can use to minimize taxes if you're aware of it and are able to utilize it. In conclusion, our session, and I've gone through it very rapidly, and for that, I apologize to you a little bit, but my experience is that if you have serious questions, it's better to deal with those questions directly rather than try to cover it in a seminar session where it may be more information than most people want, but ends up turning them off. But first of all, in all your decisions regarding planning, you're the person who plans, and you need to determine what is most important to you. Remember, the attorney, it is not their trust. It is not their estate plan. It's yours. You are the boss. Our job is to tell you what the consequences of your options are, so you can determine the option that is most beneficial to you and the people you love and care about. I encourage you to discuss these things with the people who are important to you. Certainly, that means that you and your spouse need to sit down and carefully discuss your particular situation and the issues you need to pay special attention to. You need to consider the what if questions, and you need to ask as many of those what if questions as you possibly can before you ever sit down with an attorney. Because one of the things we're going to do is ask you those what if questions. And if you've already been thinking about it, you can work with us and even hone the answers to those what if questions in a way that become even more beneficial to the people you love and care about. And finally, remember that when you write a trust and you sign it, it never changes. Those words on paper remain the same. Nothing changes. And so it's wise, in my opinion, for you every couple of years to pick that document up and read it and make sure your life has not changed in that intervening period in such a way that what you provided in the trust is no longer valid. And remember, all of us are human beings, and we're subject to a human condition. And I've watched it all my legal career. And that is, you decide you need to make a change in your trust. And you think, my sister Susie, who is the trustee of the trust now because she was young and was going to take care of the kids if I died while the kids were minors. My kids are now 45 years old, 50 years old. Susie is now 70 and is starting to show her age. And it really is time for me to move the kids into a more position of responsibility. Well, you say that to yourself 3 or 4 times, and the next thing you know, you'll be saying, I changed my trust and I removed Susie and I put the kids in as trustees. But if you get the trust out and read it, you'll see that Susie is still the trustee. And we run into that all the time where people think they've changed something and they haven't. We also run into the situation where they don't remember they changed something and they come in and say they want to do something, and we review the trust and we say, you don't really need to do anything because you already took care of that several years ago. So every couple of years, get that trust out and review it yourself. If you have questions, then make an appointment with your attorney, come in and sit down and go over the document with the attorney and make sure that it still represents the best answers to your questions. Now, I'm here because I like to serve people. Copenbarger Copenbarger exists because we want to serve people and we want to help people. So why should you choose us over all the other many qualified attorneys who are available to you? Well, first of all, we've been in continuous operation since 1979. We have 10 full-time attorneys, 2 attorneys of counsel. That just means they don't work 100% of the time. They come in and work when they want to or when we need them. We also have a CPA who is part of our staff of attorney CPA. Altogether, we have over 350 years of combined attorney experience. But most importantly, we have people who are specialized in the particular area of the law they work in. I personally am a state board certified specialist in trust, probate, and estate planning. There are 3 other attorneys in the firm who have that same designation. I have a master's degree in law and tax. We have at least 3 other attorneys in the firm, 4 other attorneys in the firm, I'm correcting myself, that have that same designation. That is important because that allows us to see tax issues that might not be recognized by a person who just practices trust and will law. We also have a very highly qualified support staff. One of the things I did when I first started in the practice of law, because I had an expertise in trust, I realized that we were going to be attracting a lot of people as clients because at that time we were among the pioneers in doing living trusts for ordinary people. And up to that point, it was only people of great wealth who had living trusts, and most of them went to a major bank as well as to a major law firm and had the work done. And so there wasn't much involved in making sure they were supported because the bank or the law firm that they went to took care of everything. And so we developed a trust administration department here. Mr. Kosaroff, who is a very highly qualified attorney, was hired over 30 years ago to head up that department. And we have in any degree of evaluation, one of the most experienced trust administration departments in the state of California. We found ourselves besieged during COVID because so many people passed away, and we had a little bit of a glitch there where we weren't able to turn things around as quickly as we normally would do so. But fortunately, we've been able to resolve that, and we're back to a more reasonable, in my view, time frame for getting trust administration complete. Also, we have people who share different backgrounds. I personally believe every person is a child of God, and it doesn't matter to me what their ethnic background is, what their heritage is. We hire people based on their capability, and we're proud that we have people of very diverse backgrounds working in our office. Also, we have 8 office locations where you can go in and meet with an attorney if you wish, and everybody can reach us by Zoom. So that's the end of my sales pitch. Again, we would be honored to serve you if you already are not represented by competent counsel. If you would like to meet with us, I'm putting on the screen now ways that you can contact us if you wish to do so. And so these are the ways that can be used to contact us. I'm going to turn the session back now to, excuse me, my staff, and I may be able to answer some questions. We'll see. We had quite a number of people part of this seminar, and so there may be more questions than we can answer in this session, but we will respond to those questions in some other way if we're unable to do it on the video. At this point, I'm going to turn the session back to my staff. Thank you for your attention. I hope this session has been beneficial to you, and I look forward to having the privilege of serving you in the future, and wish you Godspeed and good day.
Lloyd, would you like to answer a few questions?
I'll try. Yes, please.
Okay, the first one we have here is can property in a trust and an LLC be at the same time?
Yes, the way that is accomplished, and it has to be this way, the property is in the LLC, which owns the property. Then you transfer the LLC ownership to the trust. Now the trust owns the LLC owns the property. So in effect, the trust owns the property.
All right. And then another question here is, do you need a separate LLC for each property? This person has 2 rental properties and 1 primary residence property that they're going to be inheriting.
The answer is no. My advice to people in determining how much you put in an LLC is ask yourself how much you can afford to lose without it terribly adversely affecting you and your lifestyle. And you should never put in an LLC more value than you can afford to lose. So it may be multiple LLCs, it may be one LLC. And the properties you put in the LLC will be determined by you, but the attorney will help you evaluate what property should go in the LLC, whether the entire property should go in one LLC, or whether ownership should be split between a couple of LLCs so that you enhance that protection. Again, that's a decision that cannot be made without you sitting down with someone who's knowledgeable and having them go through your circumstances and come up with a personalized solution to your particular situation.
Okay, we have time for one more question here. And this question is, how long must one live in a property for it to qualify as your family home and qualify for the parent-child exclusion per Prop 19?
Well, we believe that time frame is going to be 2 years or more. It's still in the process of finalization of the regulations that govern that, but I would feel comfortable with the 2 years at this point. And if that changes, or if that becomes questionable, we will discuss that with the person at the time the parent-child transfer is being effectuated through the estate. Remember, one of the advantages of that estate administration is we're helping you solve not only the problems you have right then, but we're looking forward to problems you may be dealing with in the future. And one of the advantages of having people like Mr. Kosaroff and Mr. O'Brien and several of the other attorneys in trust administration is you're dealing with people who have helped deal with these problems for many years and can look at your situation from a position of knowing the hazards that are out there that can befall you and helping you avoid them when otherwise you might not even know they exist.
Great, thank you very much, Lloyd. I believe we're done with the presentation. So we're going to be going ahead and leaving this up for a few minutes, and Lloyd is going to be turning off the screen this time, and you guys are going to be able to fill out the evaluation, and this will help us tremendously in giving you quality webinars and anything we can do to improve. Thank you very much for your time today.